Imagine it's 2 in the morning.
The worst time for a knock on the door.
Right. Armed police kick down your front door. They rifle through your personal files, drag you out into the street, and just, lock you in a windowless room.
No phone call, no lawyer.
Exactly. And in most parts of human history, that wasn't even a violation of your rights. It was just called a Tuesday.
Yeah, just the state doing what the state does.
Right. But what happens when a nation decides to write a master rule book that makes that exact scenario, like mathematically and legally impossible?
Well, I mean, it requires a complete inversion of how we normally think about law, We're conditioned to view laws as this list of things the citizen cannot do.
Like don't steal, don't speed.
Right. Don't defraud your neighbor.
Hmm.
But the legal architecture we're looking at today flips that dynamic entirely. It is essentially a manual directed at the state.
And that is exactly the mission for this deep dive. We are stripping down one of the most vital frameworks of a nation, which is its Bill of Rights.
The absolute core.
Yeah. Specifically, we're looking at the 1987 Constitution of the Republic of the Philippines, and we're using source material from the Lawful Project Databank to do it.
It's an incredible text to unpack.
It really is. And the goal here isn't just to, recite a list of freedoms you learned in a high school civics class. We're looking at the structural engineering of this document.
The mechanics of it.
Yes, exactly. We're exploring how it builds this intricate, almost paranoid fortress around the individual, telling the government, with all its military might and endless resources, exactly where it must stop.
And to map that fortress, we are anchoring our analysis in Article 3, which is the Bill of Rights. But, we really can't look at it in isolation.
Right, because a right without enforcement is...
It's just a suggestion, really.
Yeah.
If there isn't an enforcement mechanism behind it, it's just poetry. So we have to trace the structural safety nets that are kind of woven throughout the rest of the text.
Like the Declaration of Principles in Article 2?
Exactly. And the creation of human rights watchdogs in Article 13, plus those severe limitations placed on executive power in Article 7. The drafters of this document were not writing theoretical concepts, They were building barricades.
Okay, let's start building that barricade at the absolute foundation before we get into the really cinematic stuff.
Like free speech and martial law.
Right, the stuff that makes for great movie scenes.
Yeah.
Before that, we have to establish the document's baseline philosophy of human existence.
The bedrock.
The bedrock. Article 3, Section 1. It says, "No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws."
It's a very famous sentence.
Super famous.
Yeah.
But I want to dig into the actual mechanics of what due process really means when the state wants something from you.
Well, if we view Section 1 through the lens of Article 2, Section 11, which explicitly mandates that the state guarantees full respect for human rights and values human dignity, then due process transforms from just this procedural buzzword into a formidable shield. It means the state is permanently barred from acting arbitrarily.
So let's take a metaphor I was kicking around in my notes earlier.
Okay, let's hear it.
If citizenship is like a transaction with the state, is due process essentially this rigid, non-negotiable customer return policy?
Oh, that's an interesting way to frame it.
Like if the government wants to recall my freedom or return my property to the state, they can't just, snatch it off the counter. There has to be a receipt.
A receipt, a documented reason.
Right, and a neutral manager evaluating the transaction.
Let's push that metaphor even further, actually, because it holds up really well if you look at the mechanics of the law.
Okay.
If the state wants to seize your property or your liberty, the receipt is the legal notice, right? The formal accusation or the expropriation order.
The paperwork.
Exactly. But it's not enough to just hand you a receipt.
Yeah.
Due process requires an opportunity for you to contest that receipt in front of an impartial manager, which is the judiciary.
So the state can't be both the buyer and the manager.
Right. The state cannot be both the entity seizing your property and the entity deciding if the seizure is fair.
That makes total sense.
Due process forces this massive machinery of the government to just grind to a halt, stand in front of a neutral third party, and mathematically prove why they have the right to take what is yours.
What's really striking to me about Section 1, though, is the grouping of those words. Life, liberty, property.
Mm-hmm. The trifecta?
Yeah. The text puts your physical, breathing existence on the exact same legal tier as your house or your business contracts. I always found it a bit, jarring to see real estate lumped in with human life.
I mean, it seems jarring until you consider the reality of how state power actually operates.
How do you mean?
Well, the drafters understood that physical freedom and economic freedom are structurally inseparable. You cannot be a truly free individual if the state can just arbitrarily confiscate your means of survival.
Oh, wow. I never thought of it that way. Like, if they take your farm, they're taking your life.
Exactly. Or if they forcibly relocate you. This is why Section 6 immediately follows up on the concept of liberty by protecting the liberty of abode and the right to travel.
Right. Section 6 says your right to choose where you live and your right to move around cannot be impaired except upon a lawful order of the court.
Yes.
And for travel, it does add exceptions for national security, public safety, or public health, as provided by law.
Which is a highly pragmatic concession, you know. The Constitution acknowledges that we don't live in a vacuum.
Right, like a pandemic.
A pandemic is the perfect example of the public health exception mechanically activating.
Yeah.
But the baseline, the default setting of the citizen, is absolute freedom of movement.
So the state can't just draw a red line around a neighborhood.
No, they can't just say, we don't agree with the political demographics here, so no one can leave. To turn off your freedom of movement, they have to insert a very specific, legally defined key into the lock.
Like a court order.
Exactly.
And tracing that economic protection back to Sections 9 and 10, the test gets extremely rigid about property and agreements.
Oh, very rigid.
Yeah, Section 9 is the eminent domain clause. It says, private property shall not be taken for public use without just compensation. So they actually can bulldoze my house to build a highway.
They can because the state needs infrastructure to function, right? We need roads.
Right.
But the phrase just compensation is the mechanical friction there.
The friction, yeah.
The state cannot dictate what your house is worth in a vacuum. They must pay fair market value. And if you disagree with their assessment, you have the right to drag them into court to argue over the valuation.
So they can't just write you a check for $5 and say, thanks for the land.
Right. It prevents the state from bankrupting its citizens in the name of progress.
And then Section 10 is like the ultimate stabilizer. No law impairing the obligation of contract shall be passed.
A non-impairment clause.
So if I sign a legal contract today, the legislature can't just pass a law next week that retroactively voids my agreement because, I don't know, the political winds change.
Correct. Without Section 10, economic planning is basically impossible.
Because nobody would trust the system.
Exactly. If the government could retroactively dissolve private obligations, foreign investment would evaporate overnight. Domestic businesses would freeze.
Yeah, the basic trust you need to just trade with your neighbor would collapse.
By locking in the sanctity of contracts, the Constitution removes the state's ability to weaponize retroactive legislation against private citizens.
Okay, so we've established the bedrock. The state can't just take your life, your movement, or your money without passing through this massive filter of due process.
The filter is key.
But let's move from the abstract bedrock to the physical walls of the fortress.
My favorite part.
Let's talk about the literal boundary between the citizen and the police state, which is your front door and your private communications.
Yeah, this is where the friction between state power and individual liberty really reaches its highest temperature.
No kidding.
We are looking at Article 3, Section 2, the protection against unreasonable searches and seizures.
The phrasing here is just so definitive. It says, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable.
Inviolable. That is a very aggressive word choice.
It really is.
Yeah.
But it hinges entirely on this concept of probable cause.
Right.
If the police need probable cause for a warrant, who actually defines what that is? Because, I mean, if the police decide their own probable cause, the fortress doesn't really have walls, does it?
And this is where the mechanical engineering of the Constitution is just brilliant. The text does not leave probable cause up to the police.
Okay.
It explicitly dictates that probable cause is to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce.
Wait, let's zoom in on that word personally.
Yes, it's crucial.
Does that mean a judge can't just have a clerk rubber stamp a stack of search warrants on a Friday afternoon based on, like, an email from a police precinct?
That is exactly what it prevents. The judge cannot merely read a police report and sign a piece of paper. The Constitution forces the judge to actively participate in the inquiry.
So they have to actually do the work.
They must personally examine the complainant, which is usually the police officer under oath. They must ask probing questions to test the veracity of the claim.
Wow.
Furthermore, the text requires the warrant to particularly describe the place to be searched and the persons or things to be seized.
So no fishing expeditions.
Not at all.
The police can't just get a warrant for John's house and turn the whole place upside down looking for anything remotely suspicious.
The mechanism of the general warrant is completely outlawed here.
Okay, so give me an example of how that works in practice.
Well, if the police have probable cause that there are illegal firearms in your basement, the warrant must state that specifically.
Firearms in the basement.
Right. If they are in your basement and they happen to see, say, a stolen laptop on a table, they cannot necessarily seize it or use it against you if the warrant explicitly limited their search to firearms.
Oh, interesting.
Now, there are exceptions like the plain view doctrine, but generally the state must be surgically precise about what it is looking for and where it is looking.
Okay, here is where I really need to challenge the architecture of this document.
Bring it on.
We move to Section 3, which protects the privacy of communication and correspondence. No reading my mail, no tapping my phone without a court order. Fine.
Standard privacy protections, yeah.
But paragraph 2 of Section 3 is the famous exclusionary rule. It says, any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding.
Yes. The fruit of the poisonous tree doctrine.
Yes. And functionally, this is a massive pill to swallow for a lot of people.
It is.
I understand the theory behind it, but let's look at the mechanics. You're telling me that if the police bust down my door without a valid warrant and they find, like, concrete, irrefutable evidence that I am running a massive human trafficking ring,
Right.
just a mountain of undeniable physical proof, I can go to court, point out a technical flaw in the judge's paperwork, and the entire justice system has to pretend that evidence doesn't exist.
That is exactly what it means.
How does that serve the public? Aren't we just punishing society by letting a monster walk free because a cop didn't file the right affidavit?
It is, frankly, the most uncomfortable reality of a free society.
Uncomfortable is an understatement.
I know, but it is a vulnerability the drafters intentionally coded into the system. You are looking at the immediate outcome, right? A guilty person potentially walking free.
Yeah, which is terrifying.
But the Constitution is engineered to look at the macro-level threat. The exclusionary rule is not a reward designed to protect the criminal. It is a severe structural penalty designed to discipline the state.
So it's basically starving the beast. If you take away the prize, they stop playing the game.
Precisely. Think about the alternative. If the state is allowed to use illegally obtained evidence even once, if we say, well, they broke the law, but they caught a bad guy, so we'll allow it,
They just do it all the time.
we have just incentivized the state to break the law every single time. The police would have zero reason to ever seek a warrant.
Right. Why bother with the paperwork?
Exactly. They would just kick down every door they want, knowing that if they find something, the courts will accept it. The exclusionary rule guarantees that the state's shortcuts will fatally sabotage its own goals.
So by rendering the evidence inadmissible for any purpose, the Constitution tells law enforcement, like, if you cheat, you automatically lose.
Yes. If you violate the rights of the citizen, you automatically lose the case. It forces the state to adhere strictly to the rules of the game.
Okay, that makes the mechanics much clearer. It's not about the individual criminal. It's about permanently disabling the state's ability to operate a surveillance state.
Right.
And speaking of surveillance, there is a fascinating inversion of this privacy concept in Section 7.
The right to information.
Yeah. We've established that the citizen gets this opaque, impenetrable wall around their private life. But Section 7 guarantees the right of the people to information on matters of public concern.
Yes, the right to access official records, documents, and even government research data used as a basis for policy development.
So the citizen lives behind a steel door, but the government is forced to operate inside a glass house.
I love that analogy.
The state has no right to privacy from the people.
Which perfectly operationalizes Article 2, Section 1. Sovereignty resides in the people, and all government authority emanates from them.
Because the people are the bosses.
Exactly. The government is not an independent overlord. It is a fiduciary. It's a manager hired by the public to handle public affairs.
And a manager can't hide the books from the owner.
A manager cannot hide the accounting books from the owner of the company. The public's right to access official documents ensures that the state cannot cloak its decisions, its spending, or its policy formulations in secrecy.
I just love that unequal dynamic. The asymmetry heavily favors the individual.
As it should in a true democracy.
Okay, so we've secured the individual inside their home. Their communications are encrypted by law. The state is locked out.
Secured!
But eventually, you have to leave your house.
You do.
You have to step into the public square, interact with other humans, share ideas, and, maybe complain about the government.
Yeah.
How does the Constitution build a wall around an intangible idea like speech?
This transitions us to the free market of expression, which is primarily found in sections 4, 5, and 8 of Article 3, and you really have to look closely at the grammatical construction of section 4.
Okay, what does it say?
It says, "No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances."
The first 5 words are what immediately catch my attention there.
Yeah.
No law shall be passed.
Yes.
It doesn't say, citizens have the right to free speech. It points a weapon directly at the legislature and says, do not even attempt to legislate this.
It is a negative injunction.
A negative injunction.
By phrasing it as a prohibition on the government rather than a grant to the people, the Constitution acknowledges that freedom of speech is inherent.
Like you're born with it.
The government doesn't give you the right to speak, you were born with it. The Constitution's only job is to forbid the government from taking it away.
But obviously there are limits, right?
Right.
I can't just shout fire in a crowded theater.
Right, of course. The mechanics of jurisprudence create boundaries. Defamation, inciting imminent lawless action, obscenity. These are the extreme edges where speech crosses into active physical harm.
But the default is freedom.
The baseline, the default posture of the state, must be absolute non-interference in human expression.
And it explicitly protects the press alongside the individual, too.
Yes.
It's ensuring the infrastructure of information dissemination remains out of state control.
Which is vital.
And if we look at Section 5 dealing with religion, it uses that exact same structural prohibition. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof.
The non-establishment clause and the free exercise clause, this is the state recognizing that the internal landscape of human belief is completely outside its jurisdiction.
They can't touch your mind.
Exactly. The state cannot elevate one religion over another, and it cannot punish you for practicing your faith. It creates a firewall between spiritual authority and civil authority.
Which connects back to the start of the document, right?
Yes, it's further reinforced by Article 2, Section 6, explicitly stating that the separation of church and state is inviolable.
And it goes further in Section 5, adding that the free exercise of religious worship shall forever be allowed without discrimination, and no religious test shall be required for the exercise of civil or political rights.
Which is a huge deal.
Right. You don't need a baptism certificate from a state-approved church to vote, or to run for mayor or get a government job.
If we synthesize what is happening across all these sections, a larger architectural theme really emerges.
Okay, connect the dots for me.
Look at Section 4, protecting peaceful assembly. Look at Section 5, protecting religious gatherings.
Right.
Now look at Section 8, which guarantees the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law.
Oh, wow. It's all the same thing, isn't it?
It really is.
Speech, religion, labor unions, they are just different flavors of the fundamental human right to align your mind and your body with other people.
That is exactly the underlying mechanism.
That's fascinating.
The state historically fears organized blocks of people, an organized congregation, an organized labor union, and organized political protest.
Because they have actual power.
Exactly. These are the entities that can actually challenge state power. Sections 4, 5, and 8 collectively strip the government of the power to isolate individuals.
That guarantees the right to cognitive and physical alignment.
Beautifully put. Whether you are gathering to pray, gathering to demand better wages from a corporation, or gathering in a plaza to demand the resignation of a politician, the Constitution dictates that the state must stand down and let the people organize.
All right, let's pivot. Because everything we've talked about so far, free speech, privacy, religious freedom, these are relatively easy for a government to respect on a sunny day when society is functioning smoothly.
It's true.
But the true crucible of any constitution is what happens when the state decides it actively despises you.
The darkest days.
Yeah. What happens when the awesome, terrifying machinery of law enforcement and prosecution is aimed at one solitary individual accused of a crime?
This is where the theoretical fortress is tested by literal artillery fire. The rights of the accused are designed to artificially level an incredibly asymmetric battlefield. When the state prosecutes you, they have thousands of police officers, unlimited forensic budgets, and the entire apparatus of the Justice Department,
And the individual has, perhaps, one lawyer.
if they're lucky.
Right.
Right.
And the equalization begins with Section 11, ensuring free access to the courts and adequate legal assistance, even if you're drowning in poverty.
Essential.
But the real meat of the defense is Section 14, the gauntlet of the fair trial. It reiterates that no person shall be held to answer for a criminal offense without due process.
But there's that term again.
Right. There is the presumption of innocence, the right to be heard by himself in counsel, the right to a speedy, impartial, and public trial.
Let's dissect the mechanics of Section 14 because each phrase is a specific countermeasure to historical abuses.
Like what?
Take the right to be informed of the nature and cause of the accusation against him. You cannot be arrested and simply told, well, you know what you did.
Oh, right. Like in a Kafka novel.
Exactly. The state must present a mathematically precise indictment so you know exactly what to defend against.
And then there's the phrase, to meet the witnesses face to face.
Very important.
I find this crucial because it destroys the concept of the secret accuser.
Yes, it does.
The state can't just hand the judge a signed affidavit from some shadow informant and say, trust us, he's guilty.
The confrontation clause is vital here. It forces the accuser into the light.
Right.
They must sit in a courtroom, under oath, look the accused in the eye, and subject their testimony to grueling cross-examination by the defense counsel.
So if they're lying, it falls apart.
If the state's case relies on whispers in the dark, the case collapses in the courtroom. Furthermore, Section 14 grants the accused compulsory process to secure the attendance of witnesses on their behalf.
What does that mean exactly?
This means the individual can borrow the state's coercive power using subpoenas to force reluctant witnesses to testify for their defense.
Oh, wow. So you get to use the state's tools against the state.
Exactly. You get to wield a piece of that machinery.
Okay, so that's the trial. But before you get to the brightly lit courtroom, there is the dark, incredibly dangerous period of custodial investigation.
The interrogation room.
Yes, this is where this specific 1987 Constitution becomes aggressively hyperspecific. We have to dissect Section 12.
Section 12 is perhaps the most visceral part of the Bill of Rights. It governs the moment you are in police custody.
And it starts sounding like standard police television tropes. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice.
Right, the Miranda-style rights.
Yeah, if you can't afford one, the state provides one. We know the drill. But then the text drops a massive structural roadblock.
Oh, it really does?
It says, these rights cannot be waived except in writing and in the presence of counsel.
Yes.
I want to pause here because that feels like a huge deviation from what people assume happens.
It is a massive deviation, and it is a brilliant piece of legal engineering.
Why is that?
Well, in many legal systems, a suspect can verbally waive their right to a lawyer. A police officer can simply testify in court. Well, Your Honor, I read him his rights, and he said he didn't want a lawyer and wanted to confess.
And that creates a he said, she said dynamic
Yeah.
that heavily favors the police.
Heavily. Because who is the judge going to believe? The decorated detective or the accused criminal?
Right, exactly.
The drafters of this Constitution recognized that a police interrogation room is an inherently coercive environment.
Very intimidating.
A citizen sitting alone, surrounded by armed agents of the state, is under immense psychological pressure. Any verbal waiver in that room is immediately suspect.
So what does the Constitution do?
Section 12 mechanically amputates the ability of the police to claim a verbal waiver.
Wow.
If you want to waive your right to a lawyer, you must do it physically, in writing, and your lawyer must be standing physically next to you, verifying that you are making this choice freely.
So if the police produce a signed confession, but there is no written waiver co-signed by a lawyer,
The confession is instantly void. It's inadmissible.
that completely removes the incentive for police to psychologically break a suspect in isolation.
It forces them to do actual investigative work.
But then we move to paragraph 2 of Section 12, and the text gets genuinely dark.
It does.
It says, no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. And then it has this explicit sentence. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited.
Yes. It is dark because it is a direct reflection of historical trauma.
That's what I want to dig into. A standard constitution usually just has a broad, elegant clause like no cruel and unusual punishment.
Very philosophical.
Yeah. Why did the drafters feel the need to meticulously outlaw secret detention places? Why ban holding someone incommunicado by name?
Whoa.
Yeah, and sorry, paragraph 4 even mandates that the legislature must provide penal and civil sanctions for violating this, as well as compensation and rehabilitation for victims of torture and their families.
Yes.
This reads less like a philosophical legal framework and more like a very specific post-mortem of a regime.
Because that is exactly what it is. Constitutions are not drafted in vacuums, you know. They are written to explicitly plug the holes where the previous ship sank.
That is a great way to phrase it.
When you read this hyper-specific language banning secret prisons and mandating financial compensation for torture victims, you are reading the codified historical memory of state-sanctioned disappearances and abuses.
They were writing about what they lived through.
Exactly. The drafters survived an era where broad phrases like fair trial were utterly useless against a state apparatus that utilized black sites.
They couldn't rely on interpretation anymore. They had to name the monsters specifically.
Precisely. By naming secret detention places, the Constitution weaves a permanent historical warning into its criminal procedure. It forces the state to acknowledge exactly what it is forever forbidden from doing.
And mechanically, this links directly back to the exclusionary rule in paragraph 3, right?
Yes, absolutely. Any confession obtained through torture or intimidation is completely inadmissible. The state wants a conviction. The Constitution says, if you lay a hand on this suspect, you guarantee you will never, ever get a conviction.
That is a massive failsafe.
It is.
And to tie a bow on the rights of the accused, Section 17 solidifies this by stating, no person shall be compelled to be a witness against himself.
The right against self-incrimination.
You do not have to help the state put you in prison. The burden of proof rests entirely on the government's shoulders.
And we must also look at Section 13, which guarantees the right to bail before conviction.
Right, so you're not just sitting in jail forever before you've even been tried.
Ensuring you aren't rotting in a cell for years awaiting trial, yes. Unless, of course, you are charged with an offense punishable by reclusion perpetua, which is life imprisonment, and the evidence of guilt is exceedingly strong.
So for the worst crimes, bail isn't automatic.
Right. Additionally, Section 20 provides a really crucial socioeconomic shield. It says, no person shall be imprisoned for debt or non-payment of a poll tax.
That debt provision is fascinating to me. It essentially means poverty cannot be criminalized.
Correct. You still owe the money, obviously.
Right.
And your assets can be seized in civil court to pay that debt, but the state cannot strip you of your physical liberty merely because you are bankrupt. It prevents the creation of debtors' prisons.
Okay, so we've run the gauntlet of the standard justice system. The rules are strict, the waivers must be written, the torture is explicitly banned.
A very solid defense.
But what happens when the entire system is pushed to the absolute breaking point?
The real stress test.
Yeah. Let's move to Section 5 of our outline, the ultimate fail-safes. What happens when there is an invasion or a rebellion and the state demands emergency powers?
This is where we examine how the Constitution anticipates its own potential destruction and builds in self-correcting mechanisms.
I love this part.
The linchpin of this defense is Section 15. The privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it.
Let's break down the mechanics of habeas corpus for our listeners, focusing on how it actually operates as a weapon against the state, rather than just, the textbook definition.
Conceptually, habeas corpus, which literally translates to produce the body, is the antidote to the secret arrests we discussed earlier.
Okay, so how does it work?
If state security forces snatch you off the street and hold you in a military camp without filing any criminal charges, your lawyer files a petition for a writ of habeas corpus.
Right.
The judge then issues an order compelling the military commander to bring your physical body into the courtroom and present the legal justification for your detention.
And if they don't have one?
If the state cannot produce a valid warrant or a valid criminal charge, the judge commands your immediate release.
It is the ultimate show-your-work demand from the judiciary to the executive.
Exactly.
But Section 15 acknowledges that this privilege can be suspended during invasion or rebellion.
Yes, which is terrifying.
It is. And this leads us directly into the executive powers outlined in Article 7, Section 18, which deals with martial law and the suspension of habeas corpus.
This is perhaps the most heavily engineered set of fail-safes in the entire document.
Walk me through it.
Article 7 Section 18 grants the president the power to suspend habeas corpus or place the Philippines under martial law, but only in actual cases of invasion or rebellion, and only for a maximum of 60 days.
A strict time limit. It's not an indefinite blank check.
Right.
And the president actually has to submit a report to Congress within 48 hours of doing this.
Yes. And here is the mechanical failsafe. Congress, voting jointly, can revoke that proclamation.
And the president can't just veto the revocation.
No. If Congress revokes it, the Constitution explicitly states the president cannot set aside that revocation.
Wow.
The legislature holds an absolute kill switch over the executive's emergency power.
That is a massive check on power.
Furthermore, the Supreme Court has the authority to review the factual sufficiency of the factual basis for martial law. Any citizen can file a case, and the court must promulgate its decision within 30 days.
Anyone can file it. That's incredible. But the most stunning part of Article 7, Section 18 to me is the text outlining what martial law doesn't do. It explicitly states, a state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor automatically suspend the privilege of the writ of habeas corpus.
It's a very careful definition.
I need you to explain this because the popular understanding of martial law is that the military takes over and the Constitution just goes out the window.
Right, that's what people assume. But the 1987 Constitution redefines martial law to prevent exactly that scenario.
How so?
It declares that even in the darkest national emergency, the Constitution remains supreme. The civil courts remain open and functioning. The military does not replace the judiciary.
So it's not a military dictatorship.
It's not.
Not at all. Martial law is strictly defined here as an enhanced executive power to mobilize forces to quell the rebellion, but it is not a suspension of the Republic's legal framework. And even if habeas corpus is formally suspended, the fail-safe mechanisms just keep going.
They do.
Article 7 dictates that the suspension only applies to persons judicially charged for rebellion or offenses directly connected to the invasion.
Right.
So you can't just suspend habeas corpus to lock up a journalist who criticized the government's economic policy. And the ultimate kicker, during the suspension, any person arrested must be judicially charged within 3 days. If they aren't charged in 3 days, they must be released.
3 days. That is the absolute maximum limit the state can hold you without formal charges, even when the nation is quite literally at war, even when habeas corpus is suspended.
That's wild.
The architecture here is just breathtaking. The drafters created an emergency off switch for the government, but they surrounded that switch with legislative tripwires, judicial reviews, and hard time limits that the executive absolutely cannot override.
It's an incredible display of distrust toward executive power, codified right into the highest law of the land.
A very healthy distrust.
And to ensure the mind remains free, even during these emergencies, Article 3, Section 18, guarantees. No person shall be detained solely by reason of his political beliefs and aspirations.
Thought crime is constitutionally impossible.
Okay, moving from emergency powers to the finality of state punishment, we really have to look at Section 19.
The punishment clause.
It begins by banning excessive fines and cruel, degrading, or inhuman punishment. But then it tackles the ultimate state power, which is the death penalty.
Right.
It says, neither shall death penalty be imposed unless, for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua.
It's a very loaded sentence.
I really need to push back on the architecture of this specific clause, though. It shall not be imposed unless Congress provides for it. Isn't that an incredibly massive loophole?
It is a controversial phrasing.
By abolishing it in the first half of the sentence and immediately handing the keys back to the legislature in the second half, didn't the framers essentially punt the moral question? Why bother abolishing it at all if you're going to leave the back door wide open?
It is arguably the most fiercely debated tension in the document, and you are correct that it is a compromise.
Yeah, it feels like they couldn't decide.
But mechanically, it achieves something profound. By abolishing it in the text and reducing all existing death row inmates to reclusion perpetua, which is a specific form of life imprisonment lasting 20 to 40 years, the Constitution establishes a definitive moral baseline.
It is.
The default posture of the state is that it does not execute its citizens.
But the legislature can flip the switch back on.
Yes, but look at the friction the Constitution applies to that switch. Congress cannot just reinstate the death penalty for, like, tax evasion or simple robbery.
They have to have compelling reasons involving heinous crimes.
Exactly. This places a tremendous burden of justification on the legislature. It forces society to engage in an exhausting, rigorous debate to justify crossing that moral baseline.
So it's not easy to do.
No. The framers acknowledged that they could not foresee every future crisis a society might face, so they left a heavily guarded emergency exit, but they made it exceptionally difficult to open.
Okay, that makes sense.
And crucially, paragraph 2 of section 19 requires the law to deal with substandard penal facilities and subhuman conditions, ensuring that even those imprisoned for life retain their human dignity.
The finality of the justice system is also protected in sections 21 and 22.
Yes.
Section 21 is the ban on double jeopardy. No person shall be twice put in jeopardy of punishment for the same offense. If the state marshals all its resources, puts you on trial, and fails to prove your guilt, you are acquitted.
And that's the end of it.
Right. They do not get to appeal the acquittal and try again next year with, better lawyers.
And section 22 prohibits ex post facto laws and bills of attainder.
Remind us what those are.
An ex post facto law is one that retroactively criminalizes an action. The state cannot arrest you today for something you did yesterday when it was perfectly legal at the time.
Right. You can't change the rules after the game is played.
Exactly. And a bill of attainder is a legislative act that singles out a specific person or group for punishment without a judicial trial. By banning both, the Constitution demands that punishment can only be inflicted prospectively and only through the grueling filter of the judicial system.
Okay, let's take a breath.
We've covered a lot of ground.
We really have mapped out a staggering fortress here. We've covered the baseline of due process, the ironclad walls of privacy, the open plazas of free expression, the extreme friction applied in the interrogation room, and the nested fail-safes against martial law.
It's an incredible structure, but there is a glaring vulnerability we haven't addressed.
Exactly. The paper problem. A
Yes.
constitution is ultimately just ink on paper. It's a schematic.
Yeah.
If there is no one actively patrolling the walls of the fortress, the state will eventually just ignore the blueprint. So how does this specific document ensure that the rights of the accused or the bans on secret detention aren't just empty promises?
This requires us to shift our focus from the Bill of Rights in Article 3 to the structural enforcement mechanisms in Article 13, social justice and human rights.
Okay.
The drafters knew that courts are reactive. They wait for a case to be filed. The Constitution needed an entity that was proactive. So Section 17 creates an independent office called the Commission on Human Rights, or the CHR.
And when you look at the powers of the CHR in Section 18, it's fascinating.
They are very broad.
Yeah, they have the power to investigate, on their own initiative or on complaint, all forms of human rights violations involving civil and political rights. They provide legal aid to the underprivileged. They can recommend compensation to Congress for victims of abuses.
But the most potent mechanical tool they possess is found in Section 18, paragraph 4. The Commission is granted visitorial powers over jails, prisons, or detention facilities.
Let's break down how that actually functions in the real world. Visitorial powers don't mean they send an RSVP, right?
Definitely not.
It means they have the constitutional authority to show up unannounced at a provincial jail, walk past the warden, and demand to see the holding cells.
Precisely. Remember the specific ban on secret detention places and incommunicado detention in Article 3 we talked about?
Yeah, really dark stuff.
The visitorial powers of the CHR are the physical mechanism designed to enforce that ban. They are the eyes of the Constitution. They can inspect the logs, view the physical conditions of the inmates, and ensure no one is being held off the books.
They are essentially the Internal Affairs Division for the entire Republic.
That's a great way to put it.
But here's where my skepticism flares up again.
Oh, I can guess what you're going to say.
In the real world, if an oversight committee investigates the government too aggressively, the government simply cuts their funding. If the CHR makes a powerful politician angry by exposing a human rights violation, why wouldn't the legislature just quietly defund the commission in the next budget cycle, effectively starving them to death?
Because the drafters anticipated exactly that political retaliation.
They did.
Oh, absolutely. To find the countermeasure, you have to look at Article 13, Section 17, paragraph 4. It says, the approved annual appropriations of the Commission shall be automatically and regularly released.
Well, that is brilliant.
It is the mechanism of fiscal autonomy.
So they can't be starved out.
The legislature must approve a budget for the CHR, but once it is approved, the executive branch cannot hold the money hostage. The Treasury is constitutionally mandated to release the funds automatically.
Wow.
The government cannot use the power of the purse purse to blackmail the watchdog into dropping an investigation. The brilliance of this document is that the Bill of Rights lists the promises, but the social justice article builds a self-funding, autonomous machine to physically enforce those promises.
Okay, let's do a final sweep here as we bring this deep dive to a close. Sounds good. We started by flipping the script, understanding that this Constitution is a rule book that dictates what the government cannot do.
Right.
We watched this document build a wall around the physical body and the economic livelihood of the citizen using due process.
We did.
We explored how it physically locks the state out of your home by demanding a judge personally evaluate probable cause. We saw how it protects the cognitive infrastructure of society by forbidding laws that abridge speech or religion.
The public square.
Exactly. We ran the gauntlet of the justice system, analyzing the historical trauma that led to explicit bans on torture in secret prisons and the requirement of written waivers. We marveled at the incredibly restrictive chains placed on martial law.
Those fail-safes.
Yeah. And finally, we saw the creation of a fiscally autonomous watchdog to patrol the perimeter.
It is a remarkable achievement in legal engineering, truly designed to channel, restrict, and dilute the terrifying power of the state.
And the takeaway for you, listening right now, is to recognize why these seemingly abstract mechanics matter in your daily life.
They affect everything.
Knowing the precise written limits on state power, understanding that you cannot be imprisoned for debt, recognizing that an arrest requires a specific warrant, knowing that the military cannot legally suspend the Constitution even during a rebellion, is the primary way citizens hold power accountable.
If you don't know the rules, you can't play the game.
Right. If you don't know the exact dimensions of the fortress, you won't realize when the state is slowly moving the walls inward.
If I may leave the listener with a final thought to mull over, extending beyond the 1987 text.
Please do.
As we discussed at length, this specific constitution is heavily shaped by the historical traumas of its era, which is why it contains such visceral, hyper-specific bans on secret prisons and incommunicado detention.
Yeah.
It is a document forged to fight the physical monsters of the 20th century.
Right. It knew exactly what state overreach looked like in the 1970s and 80s.
So consider this. If you are tasked with convening a constitutional convention to draft a brand new Bill of Rights for your country today, in the 21st century, what new, hyper-specific modern fears would you need to explicitly ban?
Oh, that's a huge question.
How do you write a constitutional clause to define the boundaries of your biometric data? Would you need an absolute ban on predictive policing algorithms?
Wow.
How do you enforce the privacy of communication when the state doesn't need to kick down your door because they can simply subpoena your entire digital existence from a cloud server in another country?
How do you build a fortress when the invasion is invisible and digital? That is a brilliant question.
Something we all need to think about.
The architecture of Reichs is constantly under stress, and the rulebook has to continuously anticipate the next flood. Think about that the next time you casually click agree on a digital terms of service or watch a debate over mass surveillance.
The threats evolve, so the protections must evolve.
The machinery of the state is vast, but the architecture of your rights is the only thing designed to hold the line. Keep questioning the structure. We'll catch you on the next deep dive.